What happens after someone actually files for bankruptcy? Attorney Michael McLaughlin explains.
The initial stages of the bankruptcy process involve assembling and correlating documentation and a bankruptcy worksheet, which will then be analyzed by the attorney and staff to enter data into a bankruptcy program to generate a draft bankruptcy petition. This stage can be a time-consuming task because it requires production of documentation for virtually every type of asset and debt, whether it be checking, savings, retirement, valuations of stocks, or anticipated values of real estate. The next step, regardless of whether it's a Chapter 11, Chapter 13, or Chapter 7 bankruptcy, is to attend a creditor's meeting conducted by an appointed trustee. The meeting itself is a bit of a misnomer because creditors rarely appear at this meeting, although they are provided notice of the case filing with the designated time that the meeting will occur. When filing for Chapter 13 bankruptcy, the debtor and attorney must collaborate to formulate a proposed Chapter 11 plan that provides proper treatment of their creditor claims, secured creditor claims, tax claims, and general distribution to unsecured creditors. In a Chapter 7 bankruptcy, the debtor seeks an outright discharge of all debts that are not defined to be exempt from discharge, so they won't need to prepare a repayment plan for creditors. The circumstances will depend upon the asset base for the individual or business, but the second piece is the administration, which is mostly undertaken by a Chapter 7 trustee. The trustee may have significant demands for follow-up information and review the values of real estate as well as the petition to determine if the assets of the debtors fall within the allowable exemptions or whether there's any dispute.
The law offices of Michael McLaughlin LLC is one of New Jersey's most experienced and respected in the field of bankruptcy representation. The firm acts for both debtors and creditors.